All right, folks, so now we're starting Chapter 11 of the course text, Avoiding Operational Liabilities. And again, I want to highlight some of the pieces that are important for you to take away from your reading of this chapter. And I'm starting with 11.2, Avoiding Operational Liabilities through the Record Retention Policies of an Organization. We've talked about this throughout the course. This chapter points out all of the pieces we have talked about why it's important to have a documented policy for record retention, not to mention the least of which are should there be liability or a complaint made against the nonprofit, you want to have documentation in order to go back to and review and to provide as to why decisions were made or what exactly was done. Is just good business practice to maintain documents. The problem becomes that it's expensive and takes up a lot of room a lot of times to maintain documents, so there is some interest in setting time limits for having to maintain documentation. And in the chapter there's some general rules that are pointed out as far as different documents, how long you might keep them. Just to illustrate, I think some of the ways that you start to think about what you want to retain and how long for documentation are the nature of the documents. And in my office in Portsmouth, if we have any documents that are estate planning, wills, trusts, things of that nature, documents that people may not have a need for immediately, but may need in 10 or 15 years, those are documents the policy says that we will not destroy it at any given time. Those are documents we hang on to. Some other ways to start thinking about retention policies are how long you are responsible to provide those documents. The IRS has set standards for how far back they can go in their request for tax information. You want to comply with those specific requests. If states have any kind of documented retention policies as far as how far back they can go and ask you for information, whether it be on state taxes, on your corporate filings, anything of that nature, you would want to, at the bare minimum, hang on to it for the suggested amount of time. Another thought is thinking about how long you might be liable for something, and that comes to a statute of limitations discussion. And if you can only be sued for something for 6 years, that starts to set some guidance for how long you might want to retain those documents. Although once those documents are gone, you're going to have a much more difficult time, in my opinion, trying to defend yourself or to even get to the heart of the matter of what, if anything, went wrong. Without the documents, you are relying on your memory, and mine is questionable at any given moment, so I would rather have the documents than not. Just pointing out that under the basics, it talks about most record retention discussions are triggered by 2 legal concerns. As already noted, people want to know when they can safely destroy the documents, which is some of what we just talked about. How do you start to get your hands around that without running afoul of legal rules designed to protect potential evidence, necessary and regulatory audits, lawsuits, and government investigations, as we have just talked about. And then the second being that you want to keep the records for concern, the other basis for concern is the myriad of government statutes and regulations mandating that records be kept for specific periods of time. And again, that goes to that the IRS can do a look back. I believe the last time I looked at it was 3 years. 3 years they can go back. So again, that gives you some guidance. It doesn't mean it's the that you need to just comply with the bare minimum, but it starts to put some some structure around how you want to start making the policy, or deciding the time for the policy. The other piece that needs to be considered is that you want to do your homework with creating these record retention policies well in advance of having any kind of issue arise. The worst time to create a record retention policy would be during the heart of either a legal investigation or a lawsuit, when at the least the folks asking for the documents are going to have some real concerns about why there wasn't a previous retention policy in place, and how that current situation is now impacting the retention policy that you are putting in place. Just good business practice is to think about it and get something documented and follow the procedure. Don't just document it for the effort of doing so. You need to follow through with it. You know, I think the other piece that we should think about is there's a number of kinds of records that fall into this, even though it's called document production or record retention policy. With new technology becomes new methods of storing information, and you need to have policies for all of your electronic files that you may have, and how you're going to maintain those, and not only maintain them but secure them, so that if something was to happen at your place of business, that there's perhaps an off-site facility that is housing those electronic documents for you. That's another good thought to take into consideration. Making sure that emails are maintained, that there's a policy around how long you're going to maintain and what emails you have to retain. I think that you want to take a look at page 508, where it talks about criminal acts, which is, within the last 15 years, a real concern that has, created a lot of the necessity for these docket retention policies is, people destroying records in the heart of a legal action or a government investigation, and that you need to know that should that be done, this would be really important if you were receiving federal grants, anything of that nature, and you were being accused of misusing those grants, the grant money. You want to be sure that records aren't being destroyed, because the allegation could be made that you were trying to criminally hide information, and there's some serious consequences, financial and criminal, meaning imprisonment, if you violate those rules. Assessing a document's value. Here, the American Association of Records Manager has again given some guidance, because if you read at the beginning of the chapter, there is no one right or correct way or even procedure for maintaining records. It really comes down to in-house policy in keeping up with the changes that are happening in society, and how we gather information and how we keep it, and making sure that we are always retaining records. But you want to break them down, at least this gives us some guidance into these 4 basic categories, and the value, you take into consideration the value of the record. There's the legal piece of categorizing these records. Do they fall under the legal category? Do they fall under an audit or a fiscal category? Are they operational documents, how we do our own in-house procedure, how we our employee handbook manuals, things of that nature, and then historical and archival, just records to maintain, why perhaps certain events have importance to a nonprofit, because 15, 20 years down the road, people may not remember, and it's good to have those documents stored someplace, or the information, so that you can look back at it and remember the reason for the effort and the work that might go into an event or any kind of fundraising process, why maybe a board member was so important to the organization in the history's past. So I think the other piece to look at, just to kind of have a feel for how long you should keep certain documents, page 514 and 515, there's a breakdown of different documents and in general how long you want to hang on to those. And again, this is not a strict rule, it's just guidance for you without there being a whole lot of other resources out there to try to determine how we want to create our own in-house policy. Moving forward to look at avoiding operational liabilities from employment practices. All of you will probably, throughout the process of this nonprofit management program, have to take the human resource course, and that is really where a lot of this next section of the chapter will be worked on in that course. But just to highlight, it is important to recognize that there are statutes that protect employees, even if they are not contracted employees. They are what we consider an employee at will. And an employee at will, although they are thought of to be employees that can be fired at any time for any reason, really, that is, there are great exceptions to that, and really I like to think of it as exceptions that would violate public policy, that you fire them based on one of the federally protected statutes, whether it be sex, race, religion. You would have some real concerns with terminating somebody for that reason. If they were disabled and it was known to you and you fired them on that basis, those are going to be issues that will have liability and exposure for a nonprofit. And you need to be aware that when you are dealing with employees whose livelihoods depend on the paycheck that they receive every week from the employer, that if they're terminated and it's done in a way that makes them question why it was done and what the facts were around it, that you are likely to have a report based on discrimination, at the very least, for doing that. It also, there's a piece of the whistleblower statute that also could come into play, that if an employee was following or doing something that public policy would require, like reporting an employer for violating a state, city, federal law, statute, and they were terminated after that, and it was alleged that it was done as retaliation, you're going to be bumping up against the whistleblower statute, and there are some serious penalties for that kind of an employment practice. So you want to be very cautious about how you engage with your employees, and you want to, again, right from the first moment of interviewing or advertising, before you even interview, advertising for a job, that you are clear on what the job requirements are, what you are looking for in an employee as far as abilities to perform that job, expectations. You want to talk about the things that an employee can do for training purposes. You want to be clear that when the employee comes in for an interview, that you are steering clear on any questions that are really specific in nature to the employee, that do not have to do with the employee's ability to perform the job. You want to watch out for age discrimination, race, religion, questions that there's really not a need for that kind of an information from a person. We need to know if the person can perform the work, and those are the questions that we ask, and that is what is allowed. You want to be sure that once an employee is hired, that you are maintaining good records on the employment, that you are communicating with the employee and letting them know exactly what you're looking for. An employee handbook is a good first step at starting that, making sure that policy, in-house policy for employees, that they're being asked to participate in or act upon, are clearly and effectively communicated. Any kind of complaints need to be handled either from the employer to the employee or the employee to the employer, need to be handled with respect, documented, thoroughly investigated. You want to make sure that there is some kind of policy in place that if an employee feels like they need to make a complaint against their direct supervisor or manager, that there's a process for that. Very hard to complain to your direct supervisor or manager. You want to be sure that you are following all of the state and federal regulations with regard to pay, retirement plans, the hours that somebody is supposed to be working, and that you are complying with all laws with regard to that, laws with regard to safety of employment conditions. Again, you'd want to carry on training for those employees and make it clear as to what your expectation is for training. And those are just some of the very basic things you can do to avoid having an issue between the employer and employee, which are never situations that you want to find yourself in this world, really. They point out the Fair Labor Standards Act, which imposes rules on employers. That's something you want to take a peek at. There's hours and overtime rates, how exactly you handle that. Incredibly important that you are making sure that your employees are receiving the pay in which they are promised for the work that they are doing. There are some stiff and severe penalties from the Department of Labor for having neglecting to follow through on your obligation as an employer with that. Job training, another big issue to take a look at. Child labor laws, and that we are required to follow those, and based on the age of a individual, there are specific jobs that they can or can't do and the hours that they can or cannot maintain. Family Medical Leave Act, and that's one of the statutes that needs to be recognized and comply with when an employee is asking you for accommodations under that. American with Disabilities Act. What a disability is and how you define a disability. That is based on the federal statute. It is particularly important to be sure that you're following those regulations. Reasonable accommodations under undue hardship, not right now, please. It talks about the job applicants and how you want to interview and talk with people regarding their abilities to perform employment. And I think that Fair Credit Reporting Act and how you go about actually doing testing or criminal background checks, and drug testing is where I was going with that. There are rules around that and how you can and cannot do that. You want to be getting permission from individuals before you do any kind of background checks. They have a right to refuse it, and you need to be making them aware of their rights, and you want to be careful in doing that kind of investigation and make sure that it is relevant and important for the job in which that person is going to be working in. Immigration Reform Act, it talks about the need for you to fill out a Form I-90 when you hire people, so that we're making sure that people are legal citizens, and that is the government's way in making sure that that is being complied with. Workers' compensation, you've got to make sure that you are complying with and paying for insurance for your employees in case they are hurt on the job or at work, and failure to do so in many states is going to create penalties for a nonprofit organization. And there's questions about whether you have to cover your volunteers or not under those worker comp policies, and that's a discussion to have with the actual insurer about their preference, and then also taking a peek at state law, whether it is required. Let's see here. There's talk about performance reviews and how you want to go about handling performance reviews with employees. Those are can be incredibly difficult conversations to have. It is a good business practice to have that. There needs to be structure to the way in which that performance review is done, and really the human subjectiveness of the reviewer needs to be taken out of that process. And there's some discussion about best ways to do that, but people should be clear on what it is that they are being judged upon, and what they can do, I think, to really help themselves with that performance review, so that they know just what's expected, and they can meet the employer's expectations, which is really what we're trying to do with those performance reviews anyway. There's under Chapter 11, Section 4, avoiding operational liabilities from volunteer service. Volunteers for many nonprofits are the lifeblood of the organization, and really are what make the day-to-day operations possible. So there needs to be a lot of thought and effort that goes into creating the work environment for the volunteer. Again, the chapter points out, and I think it does a great job at bulleting some of the important pieces, which you want to utilize a written job description when you're looking for volunteers to fill positions. Make sure that there is some job description that has been agreed upon by the folks at the organization who might manage or work with these people, and that is clear to the volunteer who's coming in. The best way to hang on to a volunteer and to make for happy volunteers is to match their desires and what they're trying to what they'd like to see themselves be able to achieve out of a volunteer position with the actual position. A mismatch is going to be disastrous for all involved, and that's not what we want to have happen with limited time and human resources. So a good job description and finding the right person to fit that match is going to eliminate a lot of hassle in that situation. You need to be aware that, and I think it's just good practice, regardless of whether these statutes actually apply to you or not, you want to be following the federal statutes with regard to discrimination on any level. And that, again, the book points out that taking advantage of federal grant money is going to have an impact on a nonprofit organization that might have otherwise been exempt from those same statutes. So, and that could apply to the volunteers, and you want to be very clear when you accept grant money what exactly you're being asked to do as a nonprofit. Consider handbooks for volunteers. I think absolutely that is a no-brainer. I think the other good piece here is offering employees the opportunity to volunteer um, uh, outside of work hours. I think sometimes employees agree to do that because they feel like if they don't, it will have an impact on their actual employment. Probably a best practice is to stay away from creating that kind of a situation, although hard, because as nonprofit organizations, we want a public face, and a lot of times our employees help us with that, with volunteer projects such as cleaning up. They mentioned here, keeping a roadside free of litter, things of that nature. So, although comes from a good place, probably best practice not to ask our employees and volunteers to do that for us, because they will feel that it is tied to their ongoing relationship with the employer, and that's not a good situation to create for a nonprofit organization or any organization. You want to have evaluations for volunteers as well. Have at least annual sit-down meetings. Make sure that their needs are being met, that they're meeting your needs. Discuss any ways to improve those things that need to be improved. Let's see here. Child labor laws come into place with volunteers. Something you want to keep an eye on, and make sure that you're not forgetting that there are special rules and conditions that apply to minors. And to make sure that you're clear on the rules about reimbursing volunteers for their uniforms, for gas, things of that nature, what can and can't be done in that environment. Let's see here. The chapter on, or the section avoiding operational liabilities from service to children, chapter 11, section 5, incredibly good reminder about the vulnerability of that population, and the extra steps we would take when we are hiring people who may have direct interaction with children. Background checks that are something that we take into consideration. At least 2 adults being involved and present at all times when children are involved, so that it eliminates any allegations or ability for there to be any kind of a situation where that's inappropriate. Written policies on addressing allegations of inappropriate behavior. Most certainly the Catholic Church scandal has taught us that there needs to be some, or should be some, written procedure about addressing those allegations and making sure that they are thoroughly investigated and something is done and that the situation is corrected. Considering surveillance cameras or any kind of surveillance in and around the areas where children and adults might be together. And most certainly, it says here, adopting procedures to keep track of children. When children are left with us, we become responsible for them, and we want to be sure that we know at all times where those children are for the children's safety and to limit any liability for the nonprofit organization and the good work that we're trying to ultimately do. Employee and volunteer screening, we've talked about that a little bit previously. Must be done when children are involved, and I think any vulnerable population is involved. You really want to be looking at the people that are coming into the organization and going to be interacting with the consumers of the nonprofit organization. Let's see here. Moving on to avoiding operational liabilities in workplace environment. I mean, really, this speaks to the standards that OSHA requires, which is the Occupational Safety and Health Act of 1970. OSHA has fairly rigorous workplace safety rules depending on the nature of the work, and you want to be sure, depending on what your nonprofit is engaged in, that you're complying with those and following those rules, because certainly if there's an incident of someone getting harmed or hurt on the workplace, that will be one of the first things that is investigated, whether OSHA compliance was being kept. Chapter talks a little bit about just the reasonableness of trade, and that you don't want to be in a position or engage in price fixing or any kind of restraint on trade. And that could look something like, and I think the book gives a description of it, a hospital A and a hospital B, and hospital A and B decide that they're going to treat, people from a certain geographical area, and they won't compete with each other's geographical area. That's not free trade. We are entitled to choose who we want to be treated by and when, and the business entity should not be making those choices for us. So boycotting, it talks here a little bit about a nonprofit certainly can decide who and what it wants to do business with, but it shouldn't encourage its consumers, volunteers, employees to take on that same procedure. You could have issues about whether that looks like it's an unfair trade practice. And again, that is not what we are in the business of as nonprofits. Operational liabilities arising from events. This is common sense stuff in most cases, and I think that it is the place where a lot of nonprofits probably find exposure and liability. We as nonprofits are prone to have fundraisers and events where we're asking the public to come in and to get to know us and understand our mission and perhaps become donors. And when we do that, we are opening ourselves up as the event sponsor to make sure that the people who come and attend our events are safe. And that comes down to security. If that's going to be a factor and you have enough people, you may want to have crossing guards. If it's, I'm thinking about a children's museum having an event, you're going to have a lot of families walking across a busy street. You'd want to take precautions that meet the needs of the consumers and the public that you're asking to come in, and are reasonable given the event that you're holding. Alcohol brings up an incredible liability for everyone, including nonprofit organizations, when holding an event, and you want to be sure that you're complying with, right out of the gate, the state laws governing how social hosts are, what you need to be a social. Do you need a license? Are you even allowed to provide alcohol at a certain event? If you do have alcohol, what requirements are going to be asked of you outside of the state's obligations and the liquor laws that might apply? There becomes the issue of security. With alcohol, there are likely, or there could be more likely incidents of misunderstandings, aggression, things of that nature. You want to make sure that you have enough people at your event to be watching for any issues that arise that need to be monitored and controlled. Food sales, they talk about, the service of the selling of food at these events. Again, something else that we can be held responsible for if the food is not properly maintained. 90-degree day and you're having, sandwiches that have mayonnaise on them, tuna fish or chicken salad sandwiches, and they're sitting out in the sun for 5 hours. We're going to be responsible if somebody gets sick for that. If we are putting on an event and advertising that there's food available and that we're asking them to come and share in the activities in the food, and we're not responsible for it. Of course, the caterer, if there is one, could also be responsible, but you don't want to be in the position of dueling it out to figure out who exactly was responsible. which is Chapter 12 discussion anyways. Liquor and drum shop laws we've already talked about. Fun runs, carnivals. The thing I think about here is being sure if we have road races, which are right now a very hot commodity for nonprofits, that we have maybe medical attention available to people if it's an exceptionally hot day, that we're sure that there's plenty of water and ways for runners to care for themselves if they are to overexert themselves or find that the heat is an issue. The worst thing that could happen, and the worst kind of publicity for a nonprofit, is just to have somebody get hurt at an event because the nonprofit wasn't prepared. And again, that's the board's obligation to make reasonable determinations as to what is needed based on a particular event to avoid liabilities, and it's using reasonable common sense most of the time will get us there. Talks about celebrities and musicians, hotels and rented facilities. If you do have an event at a facility, you want to read the contract about renting that space, because you could find that you're responsible if any of the guests do damage. And I have seen this. I've seen function halls destroyed from an uprising, and the host of the event is held responsible because they rented the room and assumed all of the liability should damage happen. So when you sign a contract renting something, entering into an agreement with a performer, as it talks about here, you want to read all the details and make sure you understand exactly what liability you are taking on and entering that contract. So, all right, that wraps up the chapter.